So this was a relatively active year in the areas of trademark and copyright. On the trademark side, we got decisions on whether top-level domain names can function as trademarks, whether marks for cannabis-related goods are registrable, when attorney's fees can be recovered by the prevailing party, and a decision on color mark. We're going to go through some of those decisions which came down from the Supreme Court, the Federal Circuit, and the Trademark Trial and Appeal Board. We'll also go through some procedural changes. And then briefly on the copyright side, we heard from the Supreme Court this year on whether statute annotations prepared by a state legislature are copyrightable. And we'll also look quickly at the big copyright case of the moment, Oracle versus Google. So let's get started with some notable trademarks. First up is Booking.com. This case started when the well-known travel booking company, Booking.com, attempted to register the mark Booking.com as a service mark for its travel and hotel booking services. The Patent and Trademark Office refused registration, saying that the mark was generic. Just as a reminder, in the trademark context, the generic term is typically the name of a class of goods or services, and so it's never registrable. And here there was, Booking.com was not disputing that booking by itself is generic for their services, but the Patent Office, in this case, they first of all held that Booking.com combined is also generic for online travel booking services. In other words, consumers would understand Booking.com to refer to a category of services. But the board also went a step further, and they said that a generic term plus .com is always going to be generic. So Booking.com appealed. The case made its way up to the Supreme Court, and the Supreme Court rejected any kind of hard and fast rule like the one set up by the Trademark Office. They pointed out the proper test is whether Booking.com, taken as a whole, refers to a class of services, and the court found that it didn't. Rather, people may understand anything, something.com to refer to a particular source, a particular website, perhaps. And the court pointed out also, Booking.com is not really a class of goods or services. People would not refer to their competitor Travelocity as a Booking.com website, for example. So since the term may be understood by consumers to refer to a particular source of goods, it may be registrable. And so the Trademark Office's bright line rule was rejected. So the takeaway is that there's no rule that a generic term plus .com is always going to be generic. You have to look at consumer perception as a whole. Turning next to Romag versus Fossil. In this case, the Supreme Court settled a longstanding question regarding whether a winning trademark infringement plaintiff can recover the defendant's profits. Now, there's no question that a defendant's state of mind is always going to be relevant to the question of damages. The question is whether you need to show that the defendant was actually acting willfully before their profits can be awarded to the plaintiff. And some of the regional circuits have said, yes, you do. Some have said, no, you don't. So the court took this case on to resolve that split. So this was an infringement case involving magnetic handbag fasteners. You can see them on the screen here. That's really not an important detail to the case. But anyway, the jury found that, the jury down below found that Fossil did infringe Romag's trademark and that it did so with, quote, callous disregard, but it did not go so far as to find that Fossil acted willfully. And since the Second Circuit is one of those that did require willfulness, Romag was not awarded Fossil's profits. So Romag appealed and the case made its way to the Supreme Court. The court started by looking at the statute that governs awards under the Lanham Act as Section 35, which says that a plaintiff is entitled, subject to the principles of equity, to recover the defendant's profits. So it doesn't explicitly mention willfulness. Fossil tried to argue that courts of equity had historically required a showing of willfulness before awarding profits, but the court went back and looked at those courts of equity decisions and concluded they were kind of all over the map. Sometimes those courts would award profits, would require a showing of willfulness to award profits, and sometimes it didn't. The court also pointed out here that there are other provisions of the Lanham Act that specifically and explicitly require willfulness for for a particular remedy to be granted. And so Congress clearly knew how to require willfulness if it wanted to, and it didn't in Section 35. So the Supreme Court returned to this basic principle that a defendant's state of mind is always going to be important, but there's no hard and fast rule, again, here. So the law does not require a showing of willfulness. Rather, you have to look at all the circumstances. Turning next to In re Forney. This is a case where the Federal Circuit was asked to review whether a multicolor product packaging design can function as trade dress for welding equipment. You can see the packaging in the lower right there. This is a package of welding wire, and the mark that was applied for above that. As a refresher, trade dress protection can be sought for the appearance, including the shape or color of a product configuration itself, or for product packaging. And here we're talking about packaging. So the question was whether this color scheme on this packaging was inherently distinctive as a source identifier of Forney's goods. So the Patent and Trademark Office, on first review, they took the position that packaging color marks cannot be inherently distinctive unless there is a well-defined peripheral shape or border associated with the mark. So case was appealed to the Federal Circuit, which disagreed. It pointed out that it went through all of its earlier trade dress color cases like Walmart, Qualitex, and 2 Pesos, and it pointed out that neither the Federal Circuit nor the Supreme Court had ever gone so far to set a rule that packaging color marks cannot be inherently distinctive. Now, in the Walmart case from 2000, the Supreme Court had held that color marks cannot be inherently distinctive for products themselves, the product configuration, but it didn't mention packaging. And none of the case law has ever required a peripheral shape or border accompany the color mark either. So the proper test here is whether the mark, in this case, the mark that they applied for, that yellow to orange gradient, creates such a distinctive impression that consumers will assume it is associated with a particular source, here Forney. And so that's the board should have looked at that question, and so the Federal Circuit sent the case back to the Patent and Trademark Office to consider that further. We turn next to a case dealing with a mark for nutritional supplements that include CBD oil. The Patent and Trademark Office only has the authority to register trademarks that are lawfully used in commerce. So the question at issue here was, are products that contain CBD oil lawful under federal law? If not, then the Trademark Office has no business registering them. So here the mark was initially rejected under 2 relevant provisions: the Controlled Substances Act, the CSA, and the Food, Drug, and Cosmetics Act, the FDCA, which we're going to take a look at. So again, rejected on those 2 grounds, and the applicant appealed. So we looked first at the Controlled Substances Act. This regulates the growing and cultivation of cannabis or marijuana. And under the CSA, marijuana is a controlled substance. It's illegal to grow, manufacture, distribute, etc. But Congress has carved out an exception for industrial hemp. Now that's going to be any part of the plant that has a THC concentration of 0.3% or less. So this low THC industrial hemp that meets certain other requirements is not prohibited under the CSA due to that carve out for industrial hemp. And here the applicant was seemingly able to meet all of those requirements, and so seemingly avoid a rejection under the CSA. So we turn next to the FDCA. Now this prohibits the delivery or sale of food to which a drug like cannabis has been added, where that drug, again like cannabis, is undergoing a clinical investigation by the FDA or whoever, period. There's no exemption for industrial hemp. If it contains cannabis, it's unlawful under the FDCA. So this is fatal to this application. The applicant tried to argue that the industrial hemp exemption from the CSA should also apply in the FDCA, but the board pointed out these 2 statutes really have nothing to do with one another. One deals with growing cannabis, the other, the FDCA, deals with the sale of food that may contain cannabis. So again, the exemption from the CSA has no effect on the FDCA. The applicant also tried to argue that dietary supplements are not food, but the FDCA includes dietary supplements in its definition of food. So that really got them nowhere. And then finally, the applicant here tried to argue that CBD oil supplements have been sold before CBD was under any kind of clinical investigation. But FDA documents and just the evidence in general clearly showed otherwise. It was under investigation before it had been sold as a supplement like this. So the board affirmed the refusal under the FDCA, and because that was so cut and dry, it didn't actually decide the CSA question for whatever reason. So the takeaway here is that marks are not federally registrable for CBD oil or other cannabis-containing products because of the FDCA. It makes it unlawful to use those marks in commerce. We turn next to In re Vox Populi. This is a case before the TTAB that considers whether a generic top-level domain can function as a trademark. In addition to the well-known ones .com, .net, .edu, a bunch of new top-level domains have been launched in the past few years. Things like .nyc, .xxx, .web. Brands have also launched their own. And each of these new top-level domains is administered by a company that has applied to do so. And so one of those top-level domains here is .sucks, which is administered by the applicant here. People, typically use .sucks for cause marketing, COVID.sucks or cancer.sucks, or to be cheeky kind of about their own brand name or for whatever other reason they want to. So the applicant here sought to register the mark .sucks for its behind-the-scenes domain registry operator services. So things like maintaining the database of those domains, routing traffic correctly, and things like that. So they tried to register both the word mark .sucks as well as the stylized version in the upper right here, that kind of retro computer font. So the PTO rejected both of those marks. They have a policy that top-level domains generally fail to function as a trademark because consumers are more likely to view them as a portion of a web address, not as a source of domain names. The board pointed out that all of the applicant's marketing materials really treat the .sucks domains as their product, not really as a brand. So it's along the lines of you buy a premium .sucks domain today. So it just does not function as a source identifier. The board also pointed out that, again, talking about that cause marketing, you're going to have all kinds of third parties using .sucks domains for their own purposes. So that makes it even less likely to be viewed as an identifier of a particular source of these domains. So that really does in the word mark. The board looked at the design mark to see if the stylization there, that retro font, was distinctive enough to make it registrable, and they found that it didn't. The applicant had argued that this retro style here kind of made it distinctive, but the board pointed out this is kind of just normally proportioned lettering that kind of vaguely evokes computer fonts from the early days of computing. So it just wasn't distinctive enough. So for both of these marks, the board concluded that they just failed to function as a source identifier, and so they affirmed the refusal from the examining attorney. Before we move on to copyright, we can take a look at a couple of trademark procedural changes that were implemented in 2020. Earlier in the year, the PTO announced that it was going to require an email address for trademark applicants themselves, in addition, separately from their trademark attorney's email address if they have one. And that email address would be publicly visible. So people were kind of in an uproar about this, about their email address being visible. They're worried about phishing scams and things like that. So the trademark office backtracked a little bit, saying that you could satisfy this requirement with a email address set up by the law firm that's going to monitor it. on behalf of the client. So this kind of ended up being a non-issue after that initial sort of furor. Also, at the end of this year, it didn't really get a lot of attention, but the Trademark Modernization Act was signed into law. One big thing that it does is restores the presumption of irreparable harm for injunctions in trademark cases. Up until 2006, if you could show infringement on the merits in either patent or trademark cases, courts would presume irreparable harm as part of the four-part test for imposing an injunction. But then in 2006, the eBay case was decided that eliminated that presumption in patent disputes. You now had to prove irreparable harm. And most courts followed suit and abandoned the presumption in trademark cases as well. So this the new act signed into law in December reinstates that pre-2006 presumption of irreparable harm. Other provisions in the act will allow for more options to protest third-party applications during prosecution, more streamlined procedures for challenging registrations where the mark clearly was never used, where you've got clearly Photoshopped specimens submitted. These things that have become a real problem in the past few years. And the specifics of these programs have yet to be worked out. And the Patent Office is, of course, increasing its fees because, of course, it is. Things like application filing fees, appeal briefs, petitions for cancellation. They've also created a new fee. When a registrant is renewing a trademark registration for a whole list of goods, you only need to submit evidence of ongoing use for one particular good, one specimen of use. But you're swearing under penalty of perjury that you are using it on the entire list if you're trying to renew the entire list. And so in recent years, the Patent Office has followed up. They have the right to follow up with registrants in the renewal process and ask for additional specimens for additional goods on the list. And what they found is that in many, many cases, people are then admitting, I guess, that they weren't actually using it on all those goods, and then they try to delete goods from their registration for the renewal, which you are still allowed to do, but now they're going to charge a fee of $250 to delete those goods in the middle of the renewal process. All right, so now we'll take a quick look at a couple of copyright cases arising in the past year. First one being Google versus Oracle. Here, the Supreme Court is being asked to decide one, whether software interfaces can be copyrighted, and if so, whether a fair use can be made of them. These software interfaces, APIs, are used by computer programs to reference and access software libraries and functions and so forth without needing to know all of the specifics, the programming details of those libraries. So obviously that's very important in how modern software works. It's very layered and interconnected and such. So the idea that one party could copyright this interface would and will have huge ramifications. So this case arose when Google was trying to get into the smartphone industry. It couldn't get a license from Oracle to use its Java APIs for Android devices. So Google developed its own underlying libraries, but it did use the Java API to access them. So they were sued by Oracle. The case has been up and down on appeal several times, but here's where it is now. Google has admitted that it copied parts of the APIs, but it argues that they were not copyrightable, and even if they were, it says that it was making a fair use of them. It argues that its use was fair because it was transformative. Moving the Java API from desktop computers where it previously existed to mobile devices unleashed all this creativity by third-party mobile apps and such. The Federal Circuit has rejected both of those arguments. It's found that API is copyrightable and that Google is not making a fair use of it. So the Supreme Court has heard arguments on this. They heard them back in October of 2020. A lot of the arguments focused on the merger doctrine, the idea that you cannot copyright something where there are only a limited number of ways to express the underlying idea. And Google took that position, saying that Java APIs are the only way to write code to the Java language specification. And on the fair use side, Google continued to argue that transformative fair use position that it had. So the outcome here remains to be seen, but we're expecting a decision by this June. And finally, we look at Georgia versus publicresource.org. The state of Georgia has one official version of its laws called the Official Code of Georgia Annotated. And so this publication includes all the state laws accompanied by annotations. They're not binding law, but they summarize the law. They highlight any notable decisions interpreting the law. And those annotations are prepared by a commission that is appointed by the state legislature. Now, in looking at this, the Supreme Court discussed something called the government edicts doctrine, which says that judges are not judges, as opposed to legislators. Judges are not considered authors of opinions and other works that they create in their capacity as judges. And so the effect of that is copyright only protects original works of authorship. So because judges are not considered authors, no one can claim copyright in the judge's writings, whether it's the official opinion or headnotes or whatever. The idea being that no one owns a legal opinion. And so, turning back to the specifics here, this is a nonprofit, publicresource.org. They distributed this annotated code online and in paper form, and the state of Georgia sued them for infringement only for including the annotations, because they argued that the annotations are copyrightable because they don't carry the force of law. So the Supreme Court sided with the nonprofit. It found that government edicts doctrine applies to legislators as well. Just like judges, legislators are not authors of their legislative efforts, whether these are statutory language that have the binding effect of law, or whether not. And this holds true even when the annotations are prepared by a commission that's been appointed by the legislature. It extends to that commission. The court's main concern here was that allowing these annotations to be copyrightable would create sort of an economy class version of statutes, where readers of that economy class, basically the version without the annotations, would not have the benefit of the history and the context of the statutes the way that readers of the full version would. And so it would be unjust. So takeaway here is the court extended the government edicts doctrine to legislators, preventing copywriting of statute annotations, even though they don't carry the force of law. So that's it for my portion. With that, I will turn it over. Thank you.
Hi, everyone. I'm going to be just doing a brief interlude here, looking at some significant developments, both domestic and international, in terms of IP practice. Primarily a focus on patent law developments, as Nate already presented a nice summary of some of the trademark matters. With respect to the US Patent Office, as always, their emphasis is on trying to improve overall system efficiencies and the applicant experience. Currently, they're focusing on trying to lower the pendency duration of pending applications. Obviously, it varies a great deal amongst art units, but in general, they're currently working at roughly about a 2-year estimated average time to final disposition. They're generally trying to focus on better searching, examiner routing, et cetera. But definitely one of their primary ways of improving the applicant experience and overall efficiencies is through the USPTO pilot programs. Certainly COVID internationally, of course, has sort of been one of the biggest stories of the year. And so the US Patent Office implemented a COVID pilot program, Petition to Make Special. Through this program, as implemented, so far nearly 400 applications have received prioritized examination. And so this was really a historic relief program by the USPTO. available to small entities when the subject matter of an application pertains to an FDA-regulated product or method for the prevention or treatment of COVID. Our firm has been maintaining a website documenting various COVID-related efforts at the USPTO, in the court system, and internationally. Select jurisdictions, the EPO, for example, just started holding remote hearings. They had previously put everything on hold through the end of the year. So definitely something that we've been watching closely, this unprecedented response to the COVID pandemic. The only other pilot program that was newly implemented this year by the Patent Office was the Fast Track Appeals Program. This became available as of July 2nd and is a really good option for applicants that have an appeal pending before the USPTO. For a petition fee of $400, it's now a good option to significantly reduce the duration of an appeal. The Patent Office has been doing a good job bringing down the average pendency. Back in 2015, for example, the average duration was about 30 months, and now they're closer to 14 months. But the goal with this pilot program is to get a final decision within 6 months. And the program hasn't been too widely used yet. They're willing to accept 500 applications annually. And as of the fall, again, implemented in July, only about 50 applications had been filed. It's really flexible in that there's, as long as you've received your appeal docketing notice, you can request participation. And so the guidelines in terms of timing are not terribly stringent. So that's available as of this past summer. Then there's been a couple of pilot programs that have sunset. The Covered Business Methods, this was a transitional program under the America Invents Act, looking specifically covered business methods, CBM being a defined term under the AIA. There was a concern of litigation abuse pertaining to business method patents. And so this was a special program for the review, post-grant review of CBM patents. They only received about 600 filings under the program. It did sunset just this past September. There's legislative efforts to potentially extend the program, but for now, your inter partes review or formal reexamination proceedings is going to be the approach there. The First Action Interview pilot program also just sunset earlier this month. The Patent Office recognizes the importance and benefits of having interviews with examiners, facilitating interaction with applicants. This pilot program was available for over 10 years, but really was underutilized, and that was the reason cited for sunsetting, as well as seeming confusion in terms of the procedural options following the first interview between the applicant and the examiner. But the program generally involved a prior art search and examiner interview before issuance of the first substantive office action. So I think the Patent Office is generally encouraging interviews. Increasingly, it's part of the patent examination process. I think something about roughly about 30% of patent applications involve an examiner interview. So that's definitely something that we're continuing to encourage. And finally, the IP5 PCT collaboration search and examination program. This was scheduled to move from the operational phase into the evaluation phase this past June. Here we're looking at the major international searching authorities internationally, the US, Europe, Japan, Korea, and China, that they represent in total about 96% of all the PCT international work product. Coming together, the applicant initiated to have a main searching authority and a peer searching authority working with a common set of standards to facilitate that examination, search and examination process. I think we're going to see a lot more of this in terms of collaboration amongst the various international patent offices. And I think once we have some data about how that program is evaluated, we're going to see more of that. Just a few other domestic developments. Certainly, the discussion around patentable subject matter is still a main focus, and we're going to hear about some of the related case law in just a little bit. But the 2019 patentable subject matter eligibility guidance and examples that were put forward by the Patent Office is still the most current guidance that we have from the US Patent Office. They released a report from their economist office this year looking at post-Alice decisions, citing high increase in certainty and predictability and consistency following the issuance of that 2019 guidance. One of the things that they cited too was that only about maybe less than 25% of applications now have a Section 101 patentable subject matter issue raised. But as we'll see, there's still a lot of confusion and uncertainty around the patentable subject matter debate. Two things that I see as related to patentable subject matter, the topic of artificial intelligence, certainly a big topic, both domestically and internationally. It's fairly clear at this point that the Patent Office considers only natural persons to be eligible as inventors, but there's a lot of other tangential issues that are raised when looking at inventions that pertain or involve artificial intelligence. For example, looking at Section 112 and the written description requirements, the Patent Office put out a couple of requests for public comments soliciting feedback regarding whether do we need any adjustments? Are there any special considerations pertaining to the written description requirement in this context? Or, for example, looking at the application of the obviousness standard, is there anything unique that should be defined pertaining to the person of ordinary skill in the art when evaluating the patentability of such inventions? Or even at the highest level, do we have the forms of protection that we need to adequately address AI? So I think we're going to see a lot more discussion and discourse in that regard. Separately, regarding digital designs, this was a recent request for public comment considering design patents, the statutes requiring its application to an article of manufacture, and now thinking about some of the current technologies involving projections and holographs and virtual reality and augmented reality. Do we need some adjustments to the statutes to fit within the statutory framework? Designs are increasingly, even more so, an expanding area of practice. We're seeing a lot more design applications filed in general. Nate had mentioned the fee schedule update, and one of the notable things in the most recent fee adjustment was the fee for expedited handling and examination of designs, that fee going up 75%. So that was definitely one of the ones that stood out. So we'll definitely see more about design applications in the future. The Patent Office also put out a few points of clarification and guidance. First action, final practice. This one was sort of a surprise to the patent bar, I think. There was an unprompted update in one of the MPEP revisions talking about when it's appropriate for an examiner to present to make an office action final, the first action being final in practice. The standard used to be that it was appropriate if the claims as presented are directed to the same, quote, same invention as previously pending. This change, it sounds like a subtlety, but could be significant in practice. Now, for example, after filing a continuation application or an RCE, it's appropriate for a first action final to be issued if the claims are, quote, patentably indistinct from those previously presented. Separately, looking at the standard for petitions to revive or reinstate or acknowledge a delayed priority claim. The Patent Office, looking at the standard being unintentional delay, has indicated that if such a petition is filed more than 2 years out from the critical date, they will require supplemental details. So that's something to keep in mind if those types of petitions are going to be filed. Lastly, on the Patent Office front, just looking at a few policy initiatives, there was a movement and a lot of discussion around the Orange Book and what could be done to modernize the Orange Book. So what type of information pertaining to patents would be helpful to pharmaceutical generic drug industries in terms of the listings in the Orange Book, and perhaps what adjustments might be appropriate in view of the rising prevalence of combination products in the industry. So that's something where the Patent Office has requested public comment, and I think we'll see some activity there. Another sort of trend is looking at antitrust considerations while trying to motivate and facilitate and promote collaborations and licensing and technology transfer between private industry and academia research institutions. So we're seeing some, again, public comment, but also policy initiatives on behalf of the Patent Office. Most recently, there's been some discussion around providing flexibility with respect to who might be able to claim small entity status in the context of such a collaboration, as well as maybe some adjustments to disclaimer practice, for example, the requirements for a terminal disclaimer to facilitate these types of collaborations, again, being mindful of antitrust concerns. Lastly, diversity as part of the Patent Office participating in the broader discourse on this point, how to promote innovation broadly in the context of a diverse economy. One of the things that they were considering is perhaps more of a blind application process. So a lot of the applicant data might be hidden from the examining corps. Also in this regard, a lot of studies on the participation of women, for example, in the patent process. Most recently, we saw the Patent Office announce that they might be willing to looking at adjusting the requirements for sitting for the patent bar examination. So that would certainly be a sort of a large change in practice with respect to the patent bar examination. And lastly, as always, over the past few years, most of the patent practice developments have pertained to practice before the Patent Trial and Appeal Board, or the PTAB. And Eric will definitely be touching on a number of the cases that impact PTAB practice. The Patent Office did put out a memo recently looking at the standard for evaluating indefiniteness between post-grant review proceedings vis-a-vis normal Patent Office examinations. So that's an interesting memo to check out as well. All right, I'm going to spend a little bit of time on a few international practice developments before turning it over. The big story, of course, internationally was Brexit. We, as a firm, just yesterday had a lunch and learn with one of our associates in Europe to talk about Brexit and its implications. But the UK left the European Union effective the 1st of the year. And so we're looking at its impact on both on various forms of intellectual property. So with respect to patents, we're not seeing an impact with respect to patent rights because the UK remains part of the European Patent Convention, the EPC being what implements the European Patent Office practice. And so no impact with respect to patents. However, with respect to community trademarks and designs, there are a number of updates that need to be taken into consideration. And it depends what type of, where you're at in the process. So for registrations, a trademark that's already registered will automatically be transferred to a UK or duplicated to also reflect a UK registration. And then renewals will be due in both the EU and the UK going forward. So that was an automatic update. Although we've been warned that there seems to be at least a few instances where that transfer of data hasn't been as seamless as desired. And so everything needs to be double checked and care be taken in that regard. With respect to pending applications, action is required. There's a deadline set for September 30th, in which the applicant needs to initiate the sort of duplication of the application to also be pending as a UK application. And so new filing fees need to be filed. So the September 30th deadline is something that we've been actively docketing and following up on. And then lastly, with respect to new applications, this would need to be filed in both the EU and the UK, or of course, an international application designating both the EU and UK. So potentially, significant fees and action required with respect to community trademarks and designs. So that's something to pay attention to. Again, with respect to patents, no major change. And for those wondering, with respect to the, there hasn't been any further activity with respect to the proposed unitary patent or unified patent court. And so it's business as usual with respect to getting a European patent and validating it in the various states of interest for enforcement. Just looking at a few other jurisdictions. China, there's been some substantive rule changes proposed that are already going into effect. It's interesting from the US perspective, looking to more effectively engage with China with respect to intellectual property rights. The Patent Office seems to be exerting a lot of effort studying China. There was a recent report looking at what seems to be a significant rise in filings of Chinese applicants in the Chinese Patent Office. And the USPTO has suggested that there might be some Chinese government subsidies or other non-market factors at play there. And then, so from China's perspective, looking at international trade sanctions that have been imposed and public perception is trying to do their part to bolster IP rights there and looking to harmonize more with the international community. And so some of these substantive changes that we're seeing, some having already gone into effect, for example, the availability of supplemental data being acceptable in pharmaceutical patent applications as of January 15th, as well as the availability of patent term adjustment and patent term extension introduced into the Chinese patent laws. With respect to India, just one thing that we wanted to note very briefly, those of you who have patents issued in India, the requirements with respect to the working reports have been adjusted. Now we're looking at the fiscal year as opposed to the calendar year. And a couple of the requirements that were considered overly burdensome or confusing have been relaxed. Specifically, there's no longer a requirement to disclose any licensing activity, which was sort of confidential information that applicants tended not to be comfortable submitting, as well as no longer a requirement to specify the fulfillment of the, quote, domestic requirement, which I think was a terminology that wasn't very well understood, and therefore there wasn't a lot of consistency or compliance in terms of how the registrants were reporting that information anyway. The Gulf Cooperation Council, GCC, was a regional patent cooperative filing option. It was sort of a sudden announcement at the turn of the calendar year that these regional filings were no longer going to be accepted as of January 6th. Luckily, all of the member countries are also included in the patent the PCT. That wasn't always the case, but now if you're interested in seeking protection in those countries, you have to go the PCT route or direct filings rather than through the GCC. There is a commitment apparently to continue any applications that are already pending in the GCC, but not much more information is available than that at this time. And then lastly, just sort of looking at all of this in the broader context, the USMCA agreement on trade became effective July 1st. Certainly, although not the primary focus, there were a number of important IP provisions included in the USMCA. For example, standardization around copyright term, the availability of patent term extension, and enhancing the enforceability of trade secret rights. Those were notable provisions under the USMCA. Finally, just something else that we're sort of keeping an eye on, looking at international trends and cooperation amongst the different jurisdictions, looking at standards essential patents. There seems to be a lot of discussion in this regard about how to promote good faith licensing and discussions, and what types of looking at what types of remedies should be available in the event that such negotiations fail. So standards essential patents, I think that's going to be another area where there's going to be a lot more discussion in the future. Thank you.
Hello, everyone, and welcome to the final component of today's program, where we're going to be talking about developments in patent law. So I'm going to take you through a bit of a process here. We're going to start by looking at the Supreme Court, because anytime the Supreme Court speaks on patent law, it matters. And you're going to see that throughout the day, as a lot of the cases we deal with in the lower courts are necessitated by Supreme Court decisions from 2, 3, 4 years back. So we're going to look at the Supreme Court first, then we're going to look at the Patent Trial and Appeal Board, which has been a hot topic in litigation for as long as the PTAB has been around. And then finally, we're going to finish up by looking at the Federal Circuit, both on a high-level statistical basis, and then taking a look at some specific topic areas where there's been development in 2020. I like to start by talking about the Supreme Court, because as recently as a decade ago, the Supreme Court rarely opined on patent law. So it issued a major decision maybe every 2 to 3 years. Beginning around about 2010, however, with the Supreme Court's Bilski decision, the court took on a much more active supervisory role over the Federal Circuit and patent law in general. So today, it's not unusual to hear 2 or 3 significant patent-related cases a year coming out of that court. And this year is no different. We've got 2 decisions that are worth covering. Peter versus NantQuest nominally deals with fee shifting in suits to obtain a patent, but as you might see, the implications of this decision are going to reach far beyond the scope of the case at bar. And then the second case is Thrive versus Click to Call. This deals with the appealability of time bar determinations by the Patent Trial and Appeal Board in IPR. And that case is going to be a great springboard that's going to get us into a discussion of changes in IPR practice this year. So beginning with Peter versus NantQuest. This is a little bit of an older decision, just before the 2020 break, but it's an important decision and one that's worth covering because it does affect patent rights and probably wouldn't have made it into a lot of people's year-end reviews for the 2019 time period. So NantQuest was a biotechnology company that was developing cancer treatments. Their particular method involved treating cancer using natural killer cells, as they've called it. NantQuest had been trying to get a patent since about 2001 without success because their claims were persistently rejected by the examiner as obvious. So NantQuest appealed the examiner's rejection to the PTAB, and the board affirmed the examiner. NantQuest then sued in the Eastern District of Virginia to obtain a patent. Well, what is a suit to obtain a patent? That's an avenue for obtaining a patent that many practitioners don't have much experience with. The process is set forth in Section 145 of the Patent Act, and it says that any applicant who is dissatisfied with the decision of the PTAB may file a suit in the Eastern District of Virginia. If the court finds that the applicant is entitled to receive a patent, it may grant one. But the important part of this section for our purposes is the last sentence. All of the expenses in the proceedings shall be paid for by the applicant. In this case, the PTO prevailed, and they asked for its expenses, which in this case included attorney's fees and expert fees. The district court granted their request for expert fees, but denied their request for attorney's fees, citing the American rule that litigants are ordinarily expected to bear their own attorney's fees. Now, the question arose in this case at the higher level courts: does expenses in the statute, which is distinct from costs, which is the normal term that appears in other statutes, which is distinct from attorney's fees, does expenses include attorney's fees? The panel of the Federal Circuit found that expenses did include attorney's fees. It based its decision by looking at related statutes and other statutes throughout the U.S. Code that found that expenses traditionally grouped attorney's fees in along with other expenses such as labor, money, time, resources to accomplish a result, etc. Then, of course, so what is notable about the panel opinion was that the Federal Circuit held that the American rule didn't even come into play because the American rule deals with fee shifting in prevailing party cases. But since Section 145 of the Patent Act gave shifted fees regardless of the prevailing party, the court held that you don't start with the American rule when determining whether fee shifting is part of expenses under the Act. Now, then, of course, the panel went on to analyze it as the case essentially as if it was rebutting the presumption that the American rule applied. So that might tell you a little bit about where this case is going. When the en banc Federal Circuit looked at this case, it found, in fact, that the American rule did apply. So that's where the case stood when it came to the Supreme Court. And the Supreme Court agreed with the en banc Federal Circuit against the panel opinion of the Federal Circuit that the American rule did apply. But then the court went further and expanded the rule. It held that the American rule is the starting point for fee shifting under any statute that allows for fee shifting, not just for prevailing parties. So unless there is a specific and articulated basis in the statute justifying the award of attorney's fees, in every instance, the American rule is presumed to apply. So what we have here is a express holding in the case saying that fee shifting applies in the Section 145 context, but this is a case that could reach well beyond the literal holding and reach any statute that deals with fee shifting. So that brings us to the second case I want to talk about. That's Thrive versus Click to Call, and it deals with whether the PTAB's determinations regarding the time bar for IPR are appealable. So let's talk about what this time bar is. Section 315 of the Patent Act places a time limit on how long a petitioner can wait after it's been sued in order to petition for IPR. If the petition is filed more than 1 year after the date on which the petitioner, a real party in interest, who is a real party in interest, or privity of the petitioner is served with a complaint alleging infringement, then the petition is time barred. This is essentially places a ticking clock on people who are sued for infringement. Either you decide to proceed in the district court, or you file quickly in the patent office, but it wants to discourage people from doing both. So to understand why this matters in this case, it might help to look at the case history of the Thrive versus Click to Call litigation. This case goes all the way back to 2001 when InfoRocket sued Keen Inc. InfoRocket was the exclusive licensee of the patent that's in suit today, which we might refer to as the 836 patent. After several years of litigation, Keen bought InfoRocket and inherited InfoRocket's exclusive license. Then it changed its name to Ingenio, canceled the license to the 836 patent, and sought an ex parte re-examination of that patent. The ex parte re-exam took another 4 years, during which some claims were canceled and others were affirmed. But then fast forward to 2012, Click to Call, who was the owner of the 836 patent, sued Ingenio for infringement, an Ingenio petition for IPR. That matters here because Keen and Ingenio were in privity with one another. The 2001 complaint against Keen on the same patent should have barred Ingenio from petitioning for IPR. Nevertheless, the board found that the time bar did not apply because it interpreted the statute as it interpreted a federal law as regarding the filing of a complaint that has been withdrawn without prejudice is treated as if the complaint was never filed in the first place. Since the complaint was withdrawn without prejudice, it held that the Section 315 time bar did not apply and the slate had been wiped clean. The IPR was allowed to proceed, and click-to-call's claims were found to be unpatentable. Let's be clear about one thing, though. The board was wrong. At least as of the time that this case hit the Supreme Court, there was no reasonable dispute that the board made the wrong call. Ingenio should have been precluded from proceeding in IPR. The question is, could anybody do anything about it? And the reason that's a question is because of another part of Section 314, the appeal bar. So Section 314 says that the determination of the director as to whether or not to institute IPR shall be final and non-appealable. Since the determination on the time bar was made as part of the director's determination of whether to institute, the board reasoned and the Federal Circuit agreed that the court's time bar determination was not appealable. But Click-to-Call pressed its case to the Supreme Court, arguing that the Section 314 time bar only bars appeals of determinations made under this section, quote unquote, which means Section 314 and not the 315 time bar. Well, that brings us to the basis for the Federal Circuit's decision, which is a 2016 Supreme Court case, Coazzo versus Lee. That case established that the non-appealability of institution decisions reached beyond the literal scope of Section 314, i.e., more than just decisions with respect to this section, quote unquote. In that case, Coazzo had argued that its appeal of an institution decision was proper because it was not actually challenging the decision itself, only whether the petitioner had satisfied the formalities for what a petition might contain under a different part of the law. The court held that didn't matter. The prohibition on appeals reached not only the director's decision to institute, but also any decision grounded in a statute closely related to the decision to institute. So the majority saw this case as a pretty straightforward application of Coazzo, stating a challenge to a petitioner's timeliness under Section 315 thus raises an ordinary dispute regarding the application of an instituted related statute. The majority supported this conclusion by reasoning that the IPR statute prioritized patentability over timeliness. It noted that even if a petitioner is time barred, the board can hear the same arguments from a different petitioner, albeit not one that's in privity, and a time barred petitioner can also join a petition instituted by another petitioner, even where a petitioner drops out of IPR, so there's no challenger in IPR. The board can still continue through the review and even invalidate claims. For all these reasons, the board determined it's unsurprising that a statutory scheme that so consistently elevates resolution of patentability over a petitioner's compliance with Section 315 would exclude the Section 315 appeals, thereby preserving the board's adjudication of the merits. Now, I will note that there is a dissent in this case by Justice Gorsuch, and I think it's really a really good dissent for anyone who's interested to read. Justice Gorsuch has dissented in other cases in recent years along similar lines to his dissent in this case, including the 2018 oil states decision regarding whether patents were a public franchise or private ownership. Justice Gorsuch has taken a very strong position in favor of patent owners, and he's continued to hold this position even in later cases. So we might be seeing something of a tension between the current majority on the Supreme Court and a minority right now led by Justice Gorsuch. And this matters because traditionally in patent law, you don't really see the sort of partisan divides or consistent teams spring up on the Supreme Court as you might in a lot of other areas of the law. So if we're starting to see one here, it's important to pay attention to because these issues are going to come up again and again and again over the next several years. Now, there's one more Supreme Court case that we are looking at but hasn't been decided yet. This is Arthrex versus Smith and Nephew, and it's set for argument on March 1st. It deals with whether administrative patent judges were unconstitutionally appointed to the PTAB because administrative patent judges have very little accountability to anybody, and their lack of accountability makes them much more like principal officers, like cabinet officials, as opposed to subordinate officers that could be appointed by the president or a director of an agency alone. Now, the interesting thing about this is everybody basically agrees that PTAB judges were unconstitutionally appointed. The only question is, what do you do about it? Again, so what we're looking at here is not necessarily is going to be whether the Supreme Court accepts the Federal Circuit's more or less easy fix to this issue, or if they're searching for something that's much more disruptive to the board as a whole. And this, again, might be something worth paying attention to, the division between Justice Gorsuch and the current majority of the Supreme Court, because this is another area where that division might rear its head again. So that brings us to inter partes review, and specifically the conduct of proceedings by the Patent Trial and Appeal Board. So I want to focus on one decision here that is going to be extraordinarily important to IPR practice going forward. That's the Apple versus Fintif case and the PTAB's development of a multi-factor test for exercising their discretion to deny IPR petitions that they would otherwise be permitted to accept by statute. So this case was necessitated by a 2018 Supreme Court decision. Again, going back to the Supreme Court changing everything and disrupting patent practice going years forward. So the Supreme Court case was SAS Institute versus Iancu. Prior to SAS, the board interpreted its own statute as giving it discretion to partially institute IPR in a petition. If a petition articulated 5 grounds of invalidity, the board could accept one and reject others and proceed only on the grounds they decided to hear. The Supreme Court ended that practice with SAS. Under SAS, the board's only options are to institute or not. But this posed a real problem for the board. The inability to partially institute review had the potential to dramatically increase the board's workload. Fortunately for the board, it also had a workaround. That is, its authority is grounded in Section 314, a statute we have discussed in the previous cases. Under Section 314, the director has been interpreted to have discretionary authority. That is, the statute says the director may not authorize inter partes review under certain circumstances, and the court has held that this also means that the director may, but is not required to authorize under different circumstances. So this is a may institute statute, not a must institute statute. The board is never required to institute inter partes review. Well, so the board responded this year by articulating a new test for exercising its discretion not to institute IPR on petitions that might otherwise satisfy the statutory prerequisites for IPR. These are the Fintif factors. Now, I'm not going to read them to you overall, but I am going to tell you kind of what they represent. So factor number 1 here is a factor that you might say goes to the comity between the courts and the PTAB. It deals with the question of whether the court has granted a stay or evidence exists that one may be granted if proceedings are instituted. And this is based on the board's preference to not cover the same ground in IPR as being covered by the district court. So if it's clear that a district court is not going to stay a case if IPR is granted, then there's an incentive for the board to deny IPR. Now, this matters a lot for some courts that want to hold on to their cases. I note recently that the Western District of Texas has taken the position that it will basically never grant a stay pending IPR. So under these Fintif factors, it's going to be really, really hard for parties sued in the Western District of Texas to get their case heard by the PTAB instead of the Western District. Now, other factors, and I'm going to note factors 2, 3, and 5, primarily penalize people who sit on their rights. So even though you have this 1-year time period to file your petition for IPR, the board is going to look very disfavorably on it if you file close to that deadline. It wants people who file really early in the case, and it's going to hold it against you if you don't. Now, factor 4 here is another one that goes to, I guess, what you might call comity issues. It penalizes people who tend to raise the same issues before the district court and IPR. So then number 6, you might call this a catch-all. The way the board has interpreted it, they're treating this like a way of weeding out low-quality petitions that might meet the statutory grounds for instituting review, but overall probably wouldn't end up invalidating most of the claims after a full decision on the merits. So all of these factors are incredibly consequential to a party's decision whether or not they're going to proceed in IPR, when they're going to proceed, and how they want to proceed. every single petitioner going forward needs to have a strategy when they're sued in district court. If they want to go before the PTAB, how they're going to do it, how they're going to deal with these fintive factors. So I cannot stress enough, these fintive factors for IPR practice are going to be a big focus for litigants going forward. Now, that brings me to the Federal Circuit. I like to start by taking a high-level look at the Federal Circuit, beginning with some Federal Circuit statistics over the last fiscal year. So let's take a look at historical caseload for the Federal Circuit. This is all based on data that's published by the court itself. And the one thing that stands out for me is that you almost always see a noticeable spike in caseload when there's been a significant change in patent law. For instance, you see this first spike from like 1983 to 1985, and that's because that's when the Federal Circuit was founded. You see another one right around 1995. That's when the United States joined GATT and took steps to harmonize its patent system with the rest of the world. And then you see another big spike. The most recent big spike you see is right after the passage of the AIA. So it's a few years after you start to see these AIA issues entered the Federal Circuit, and that created a huge new spike in caseload. Now, that's not the whole story here. Right around this time period, like 2013, 14, 15, 16, you're also seeing the huge upheaval in Section 101 litigation. That contributed to it as well. But so this is not expected to be exhaustive of all the reasons you might see litigation spikes. But I think it's really interesting to just look at this and see how changes in the law can affect the caseload. And it goes to show, which changes are really consequential in terms of driving litigation and which other ones, maybe might just fall by the wayside or may not be that important to most litigations most of the time. Now, as far as this year, caseload is down. That has a lot to do, with the COVID pandemic, but it might have something to do with other issues, some case issues that we talked about dealing with the Supreme Court, and some of the other issues that we're going to be talking about later. Now, I want to take a close look at the types of cases that are making up this caseload to give you an idea of how that's changing. Now, there's one very noticeable shift in 2020 cases as opposed to 2019, and this is the first year since the AIA appeals began that the proportion of cases coming from the PTO has gone down relative to cases coming from the district court. So if you look on the left here, in 2019, PTO appeals represented 43% of all Federal Circuit cases. In 2020, they represented only 38%. That's a significant shift, especially considering the proportion of cases coming from the district court didn't really change that much, 22% in 2019 to 21% in 2020. Now, if we compare that against a chart taken just before AIA appeals began hitting the courts, the historical, you can really see this difference in stark contrast. This is a historical caseload from 2013. Here we see that the district courts make up 36% of all appeals to the Federal Circuit, while PTO appeals only make up 9%. So this just goes to show how incredibly consequential IPR has been to federal patent law and federal patent litigation, and that it has created this huge shift away from the district courts into the patent office. And you're only just now in 2020 starting to see that shift work its way back a little bit and a little bit more focus going back to the courts. So one of the things that might be driving this shift back to the courts could be a change in venue determinations. And so we're going to explore that as a deep dive into Federal Circuit litigation today. So this is not an issue that's normally heavily litigated by the Federal Circuit. It became a hot topic because of a 2017 Supreme Court decision that radically disrupted traditional venue determinations in patent litigation. So I'd love to recap the entire history of patent venue before the Supreme Court changed everything in 2017 with its TC Heartland decision, but the topic is just for another day. So I'm just going to talk about how things currently stand. Just remember, this is a radical departure from pre-2017 law, which is why there's so many cases about it today. Currently, the only appropriate venue for patent litigation suits is where defendant resides and where a defendant has committed acts of infringement and has a regular and established place of business. Those are your two options. So under the Supreme Court's previous construction of the patent venue statute, a corporation only resides in the state of its incorporation. So all the interesting case law dealing with this decision has focused on the regular and established place of business prong. So what is a regular and established place of business? The Federal Circuit has articulated a test. And this test may not be the most helpful one. Again, that's driven by the Supreme Court, because the Supreme Court has in recent years repeatedly reversed the Federal Circuit for articulating mandatory multi-part tests that are divorced from the statutory text. So the Federal Circuit has taken notice. And now when it creates a test, the test is A, non-exclusive, and B is something that's going to hew very close to the statute itself. That gives us the in re Cray test. A regular and established place of business is a physical place in the district that is regular and established and must be the place of the defendant. So helpful, right? It provides such a great explanation for what a regular and established place of business is over the statute. Unfortunately, that's the way the Federal Circuit feels it has to be in view of the lessons it's been taught by the Supreme Court. So that leaves a lot of open questions. In particular, one question that's been dogging the courts since roughly 2017 has been addressed by In Re Google. That's whether a server rack in this case could be a regular and established place of business. We see a server farm here. This is taken from Google's briefs in an earlier version of this case, a 2017 mandamus request. And it shows that what was deemed Google's regular and established place of business was this rack of servers. Now, Google is the record owner of this rack of servers, but is managed and administered by this server farm in the Eastern District of Texas. Google had never been to this server farm. It had never sent employees there. It had never physically touched those servers. But the Eastern District held it was still a regular and established place of business. It took several years, but the case has finally come to the Federal Circuit. The Federal Circuit expanded on its three-part test here in several ways to help define ways that things might or might not be a regular and established place of business. In this case, a physical place in the district means that leased shelf space or a server rack could be a place. It also found that under the being a place of the defendant, this is not restricted to real property that the defendant owns. It could be something as simple as like a stall in a flea market, which if regularly set up and regularly maintained by the defendant would be a regular and established place. The question here, the deciding factor here was whether it was a regular and established place of business of the defendant. And that generally requires some agent or employee to be conducting business at the place. That means here, not a server rack because there were no employees there. So that meant that server racks are not regular and established places of business, and it gives people at least a little bit more guidance over the Cray test as far as what a regular and established place of business might be. Now, there were other important venue decisions in this that came out of the Federal Circuit this year as well. There's one for abbreviated new drug application cases, which is particularly applicable to anybody involved in the pharmaceutical or drug development industry. And that held that venue is only appropriate where acts occurred that would make the accused infringer a submitter of an ANDA application under the Hatch-Waxman Act. Another one that is important here is another one about Texas. This does not deal with statutory venue under Section 1400, but deals with venue transfers for reasons of convenience. Now, in this one, the Federal Circuit really came down hard on the Western District of Texas for what it considered to be a lackluster venue or forum transfer analysis, and the most important thing it attacked the court for was that after the venue transfer motion was filed, that motion should have taken top priority, but it didn't. The district court went on to deal with other issues attacking the merits of the case, and the Federal Circuit held that once you have a venue transfer motion filed, it needs to take top priority in handling. Other matters have to be secondary. So these forum issues get dealt with quickly and are resolved finally before you attack the merits of the case. Now, I'm briefly going to touch on some other major areas of Federal Circuit decisions. I'm not going to go in depth in these, but if you really want to take a look at it, I've highlighted a few cases that are meaningful and highlight where I think the court is going or was going this year and where they might be going in the coming year. So Section 101 is is something that I don't often comment on, even though the Federal Circuit is always issuing Section 101 opinions, because in past years, it really didn't seem like most of the Federal Circuit's decisions really moved the needle much on Section 101. But we're seeing a significant development this year, particularly under Alice Step 2. That is additional claim limitations that might transform an abstract or not patent eligible concept into something that is a patent eligible claim. We have CR Bard versus Angiodynamics. This dealt with a patent to portacath markings, and it was analyzed under the printed matter doctrine, holding that printed matter that is claimed only for the content of the information is not patent eligible. However, in this case, it found that that other limitations made the markings on portacaths to determine whether these portacaths were capable of accepting high flow injections. Transformed the claim into something that might be patent eligible under Step 2. Another one that we've actually been following for a while is a panel rehearing in American Axle Manufacturing versus NEPCO. And it's one of those rare Section 101 cases that invalidated claims to an ostensibly mechanical invention. Now, the panel rehearing walked back its invalidity determination with respect to one claim that added an additional limitation beyond the abstract ideas that the court complained about. So if you want to see something of this, the dividing line between what is patent eligible and what isn't, this might be a good one to read, because it shows how what you need to add to transform an abstract concept into something that at least might satisfy the Alice two-step analysis. Another issue that has been addressed by the court this year has been questions related to the specification, specifically the specificity of it and the sufficiency of it. I've highlighted a couple of issues here. One was an enablement case, McRow versus Bandai Namco Games. It deals with some really interesting technology, and it's worth a read just for that. It says that proof of lack of enablement shows that it requires a challenger to show that specific content is covered by the claims, but is not enabled. And the reason for this holding is because in that case, the challenger had argued essentially that the claims were too broad and said that the disclosure was too narrow, but it couldn't point to anything specifically that the claims covered beyond saying the claims were just vague. So the Federal Circuit refused to find those claims to be non-enabled, saying you actually have to specifically identify the content covered but not enabled. Another one deals with is Eagle Pharmaceuticals versus Slayback Pharma, and it deals with the tension between the doctrine of equivalence and the disclosure dedication doctrine. The doctrine of equivalence allows a patent's claims to cover things beyond the literal scope of the claims if there's a good reason why the patentee couldn't have reasonably claimed that subject matter at the time of its filing. That is in tension with the disclosure dedication doctrine, which says if you disclose specific subject matter in your specification, but do not claim it in your claims, that subject matter is dedicated to the public. And in this case, it found the doctrine of equivalence did not apply, the disclosure dedication doctrine did, and that the claims were found to be not infringed by virtue of that. The last major issue that I think the court is dealing with, Federal Circuit is dealing with, deals with IPR scope and authority. And this is not unusual. It's been dealing with it since the IPR became a thing because it's just a new area of law. So we've got Facebook versus Windy City Innovations. This is an IPR case, says same party joinder and joinder of new issues is not permitted. This really cabins the joinder ability in IPR into a really narrow, limited window. You're allowed, if you have an interest in an IPR, to join it simply to have a voice in issues that were raised by somebody else, but you're not allowed to raise new issues on your own accord in another person's IPR, or even your own IPR, frankly. The other one that I want to mention here is Unilock versus Hulu. And this says that the board can consider patent eligibility when evaluating proposed substitute claims offered by amendment in IPR. And this matters because the jurisdiction of the board otherwise doesn't permit them to consider patent eligibility questions, only anticipation and obviousness on printed matter. So I don't think this is a case that's going to go away, and it's not an issue that's going to go away. We may see other decisions related to it here, and if you had to ask me, this would probably be one of the good candidates for going to the Supreme Court, either this year or on another case in coming years. Now, what you're not seeing from the Federal Circuit are too many cases that are really affecting obviousness and anticipation. I mean, you're getting decisions, obviously, but few that really make substantive changes to the law. And a lot of that has to do, again, with the PTAB. A lot of the overwhelming majority of Section 103 obvious determinations are going not through the federal district courts, where there's a very high bar to obviousness, but they're going through the PTAB, where the only thing the PTAB needs to show in order to support an obviousness determination is substantial evidence. So you're not seeing much development in the case law here because it's a really lenient standard that leans heavily on the board. I don't expect this to change. So going forward, if you want to see developments in 103, obviousness and anticipation law, you're going to have to look at the PTAB, not necessarily the Federal Circuit. So I want to leave you on just a few concluding thoughts here. So what we're seeing is major decisions in the Federal Circuit and the PTAB are being driven by Supreme Court decisions over the last few years. Textualism dominates. That means everything is guided by a close reading of statutory language. That matters to cases decided this year, and it matters to cases that were decided in the last several years, and you're going to see this coming up over and over again. So any case involving statutory interpretation, really the focus is going to be, what does the statute say? Because you're not going to get much farther away from what the law requires than what the literal statute says. And if you want the law to be better, your recourse is through Congress, not trying to create judicially created tests. And the last thing is the overall theme of this year. This year has been about realignment. Which cases should be brought, where cases should be brought, whether the PTAB or the courts, and if so, which courts. Some of this is being driven by previous Supreme Court case law, but it's also being driven by the pandemic and courts trying to adjust their workload. Some district courts are trying really desperately to hang on to cases. The PTAB is trying really desperately to lighten its workload. And the Federal Circuit is trying to more aggressively check venue determinations between either the board and the various district courts. So this is all stuff that I think you're going to keep seeing as this year and in future years. And this is going to be a really interesting year for the Federal Circuit, the Supreme Court, and the PTAB, especially once we start to come out of the COVID pandemic. So that's all I really have for you today. And I just want to thank everybody for joining me for this component of the program, and joining everyone for our program as a whole.